Everybody, I'm Chandra Andrade. Pleasure to have you all with us today. I'm a partner in Firella's employment practice, where I represent companies in employment-related litigation and also advise management on complying with the various employment laws governing their business.
Good morning, everyone. My name is Rebecca Stephens. I'm a senior associate in the employment practice group, and my practice is similar to Chandra's, representing and advising employers in all manner of employment disputes and issues.
Hi, I'm Nate Garhart, and my practice focuses on intellectual property, trademark, copyright, and advertising, as well as internet issues and privacy.
So what are we going to cover today? Nate's going to take us through various relevant intellectual property that covers employers and employees in that relationship. We'll talk about copyright, including works made for hire, as well as assignment, patent, trade secrets, and within that, we'll talk about non-disclosure agreements, as well as right of publicity. And then Rebecca and I will tackle some of the employment applications of incorporating IP protections into employment agreements and the like. We'll also talk a little bit about independent contractors and some of the implications for them compared to employees, and then we'll wrap up with some best practices in these areas.
Thanks, Chandra. So first of all, I have to preface this by saying yesterday's presentations were fantastic, and it's definitely a tough act to follow. I also would note that Professor Kang made it clear that height is directly correlated with authority, and therefore I think it's important that you all know that I am 6'5", and if you believe that, let me know. I have other things I can tell you as well. But at any rate, let's get started. So my role here, we're really going to focus on the employment issues and making sure that your company owns the materials that it thinks it owns its IP. But in order to do that, I just want to touch base on the basic areas of intellectual property, so we're all on the same page, and we'll address the employment issues with each of these. So just the main categories. Copyright. Copyright protects original works of authorship, generally all the creative works that you know and love: books, music, plays, movies, software, websites, all of these creative items that are fixed, and I'll talk more about that. Patent, on the other hand, protects useful inventions, and so it differs from copyright. Most things, and we'll talk more about software, but most things protected by copyright are not particularly functional. On the other hand, patent protects functional inventions. The right of publicity is just a small little aside here, but that has to do with individuals' right to control their name and likeness. And then we'll talk about trade secrets. Trade secrets are the secret sauce of a company, things that are kept confidential and they have value. So you might ask, everybody is familiar with trademark law. Why am I not talking about trademark law here? Basically, trademark law is not a big concern with your employees because trademark rights arise from the use of a mark. And so in order to have trademark rights, you have to use that mark in connection with goods and services. Additionally, in order for you to have rights against a third party, that use has to be in connection with similar goods and services. So if an employee used a mark for services unrelated to yours, it wouldn't be an issue for the most part. Additionally, if they used a mark for services similar to your own, it's probably a problem under your employment agreement generally, and it's not so much the intellectual property issue. They're simply unlikely to have rights in a mark that the company would want to own or have. So less about trademark today. So why is IP important? Well, it's money. IP is an important asset of the company and therefore has all the benefits and issues that you consider in connection with the main assets of the company. Indeed, many times IP amounts to the only assets of the company, the only significant assets to the company. So it can be very important. So let's start talking about copyright. I mentioned that it protects creative works. Well, a little more specifically, it protects any original work that is fixed in a medium of tangible expression. That's the actual language from the Copyright Act. Well, that's a long-winded way of saying it creates anything or it protects anything you create that you have recorded, written down, fixed in some way. So what's not fixed? What's not fixed might be an impromptu performance that's non-scripted. That would not be protected. However, if that were recorded, filmed, or audio recorded, that recording would be protected. So it definitely needs to be fixed. The other classic example of something that's creative and communicative that's not fixed would be smoke signals. That's kind of the classic example that's used in classes to talk about what is not protected by copyright. At any rate, most of the things that will be created for your company that are original works will be protected by copyright. So copyright exists upon creation of the work. That is, the minute the work is created, it is protected by copyright. Registration is not required, but it is very important, and we'll talk about it a little more in a second. It's also important to know that unlike trademark, where trademark has two different symbols for when you want to identify something as your trademark. If a trademark is not registered, you use the little TM at the end. If it is registered, you use the circle R. Copyright doesn't have that distinction, and any work, whether registered or not, if you want to give notice that you're claiming copyright in that work, you use the circle C. So I said that registration isn't necessary. So why would you want to register? There are a bunch of reasons listed here. The key one is you cannot enforce your copyright, your rights in the work in federal court without having a registration for the work. Additionally, it gives you certain additional benefits and remedies, including statutory damages, enhanced damages, and attorney's fees and costs. Note that for the statutory damages, enhanced damages, and attorney's fees and costs, you would need to have the registration in place for the most part prior to the beginning of the infringement. So what's the moral here? Register early, register often. Copyright registrations are actually pretty cheap. The fee is $45. It doesn't take a lot. So it's definitely worthwhile to register copyrights in your creative works, in the works created by and for your company. So who's the owner of the copyright? Well, it's presumed that it's going to be the author. Usually whoever creates the work, the individual that creates the work, is the owner of the work. But that can change in a couple of situations. First is where it's assigned, the author assigns it to somebody else, or it can be the employer rather than the individual, where the work is a work made for hire. Now you're going to hear this term a lot, and I'm sure you've heard this term a lot and seen it a lot in agreements. There's a lot of confusion about it, and we want to clear that up. So we'll get to that in a minute, but in the meantime, what about assignments? First of all, they have to be in writing. Copyright cannot be assigned by an oral agreement or an implied agreement or anything. It has to be in writing. It has to include a present assignment. So you can't say, well, you can, but it wouldn't be wise to say that the individual will assign this copyright in this work down the road. Instead, it has to say that the individual hereby assigns it. And a lot of times the question arises then, well, what if the work hasn't been created yet? So I'm hiring somebody to create something and I want that assignment, and I have them say, I hereby assign it, but that work hasn't been created yet. Well, the law has taken that into account. The case law is clear. The present assignment will work to assign that future created item. And then finally, you want to understand the issue with legal termination. And that is, with an assignment, the assignor can cancel that, can terminate that assignment after 35 years, between the 35th and 36th year after the assignment. That obviously could be a big deal if you have long-lived materials. On the other hand, most things that are being created that a company is getting through assignment don't live that long, don't have that long of a useful lifetime. And therefore, it's not usually a big deal. You may have heard a little bit about this recently. Some musical artists have been canceling assignments that were made to their music production companies, their record companies. a while ago, and they're terminating those agreements to get that music back, to get the rights in that music back. But for the most part, shouldn't be that big a deal to a company. That said, it would be better not to have that situation. So how do you not have that situation? Where it's a work made for hire. And the idea with a work made for hire is if something is a work made for hire, then the individual author is not the owner of the copyright, is not seen as the author. Instead, the employer is seen as the author. And so it's beneficial because no assignment is necessary and there's no concern about that termination down the road. So when can something be a work made for hire? There are two situations. First of all, when something is created by an employee within the scope of their employment. So they don't just have to be an employee. What they create has to be something that they were hired to create and would be likely to create considering their job title. So if I am a software engineer and I create a piece of software for the company that the company has asked me to create, very likely, well, in fact, definitely, that would be a work made for hire, and the company, not the employee, would be the author of the work and the owner of the work. Now, on the other hand, if that same software engineer creates a, let's say, a party invitation that's very creative and very interesting, and the company wants to use it again and again down the road, well, it's going to have to get permission from that software engineer to use that invitation again and again, because the software engineer is actually the owner of that work because it was not created within the scope of that employee's employment. So that's where works are created by employees. And that's the main area that companies will be the author and owner on the basis of works made for hire. There is another possibility, and that is where you hire an independent contractor to commission, and you commission a work by that independent contractor. And it's in writing, and the writing states that it's a work made for hire, but note that it only applies in very limited circumstances. So what are those circumstances? In order to qualify as a work made for hire, the work created by the individual independent contractor has to fall into one of these categories. The main one here, and the one that makes the most sense, is part of a motion picture. Imagine if a production company that's putting together a movie hires all these different independent contractors to do various tasks within the movie, cameramen, sound recording people, etc. At the end of the day, they would need assignments from each of these individuals in order to own the movie, and they would have all of these termination rights would be a concern, etc. However, if they instead use an independent contractor agreement that has a work made for hire clause, excuse me, in that situation, because it's part of a motion picture, the production company would end up owning all of those individual contributions. And so it really makes sense there. But you have to look at these categories and consider for the job that you're hiring this independent contractor for, will their creation fall into one of these categories? And I gotta say, the answer is most often no, it won't. And so the question then comes up that I get a lot, why not put in a work made for hire clause as well as an assignment, so that if it's a work made for hire, if I can argue that it falls into one of these categories, then it would be worth it to have it there. So why not do it? So what do you think? Should we add a work made for hire clause to our agreements with independent contractors, just in case, it turns out to be a work made for hire? I'll give it another minute. Finish up the polling. 10 more seconds. All right. So we came out pretty much could have some unintended consequences. Some people admitted they're not sure, and a few people thought it was a great idea. Well, here to talk more about this is, sorry, I'm getting this moving, is Chandra. Thank you.
Yeah, thanks everyone. So as Nate mentioned, independent contractors provide an important source of labor for many companies, particularly those needing specialized, discrete work that's outside the usual scope of the company's business. We'll hit a little bit more on independent contractor relationships in a second. And usually the parties will enter into a written agreement that governs the relationship, including the ownership of materials created by the contractor and providing the requested services. And so as Nate touched on under the Copyright Act, where the agreement is silent as to ownership of some created materials, and if there's even no written agreement in place at all, then ownership will vest in the contractor and not transfer to the employer. And controlling law makes clear that the employer would still be able to use materials under a non-exclusive license, and that that license would be irrevocable since it's supported by consideration. But of course, the lack of exclusivity and the lack of clarity around the scope of the employer's use under the license, all that weighs against reliance on such kind of implied license rights. And for this reason, employers are wise to include language positing rights in the contractor's work product in the employer. And so again, as Nate mentioned, there are two main mechanisms to do this, either the work made for hire clause or an assignment. The challenge, I think, with a lot of employers kind of recycling templates for their independent contractor agreements, particularly around IP rights, is there's this assumption, let's just throw it all in. Let's include a work made for hire clause, let's include an assignment clause, let's maximize the intellectual property rights and options here. And the approach that encompasses both of these options, sort of carte blanche, ignores an often overlooked downside to using the term work made for hire in an independent contractor agreement that can create these unexpected issues for employers. So for folks who chose I think it was the second option in the poll, that you were right there, that there's unintended consequences for using both in an agreement. The reason is that multiple California statutes provide that using a work made for hire clause in an independent contractor agreement actually transforms that contractor into a statutory employee. And that's for a couple of discrete areas in California employment world. For starters, workers' compensation law. And so under California Labor Code section 3351, I haven't quoted it all there for you, but I'll read what the statute says. It says employee includes any person while engaged by contract for the creation of a specially ordered or commissioned work of authorship in which the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire, and the ordering or commissioning party obtains ownership of all the rights comprised in the copyright in the work. And so what that's saying is that the definition of employee for purposes of workers' compensation law and protections encompasses those who sign an agreement that provides for work that their work would be considered a work made for hire. And there's a similar provision in the California Unemployment Insurance Code that we've cited there, which governs entitlement to both unemployment and disability insurance benefits as well. So what's the upshot here? Well, it's that employers must obtain workers' compensation, disability, as well as unemployment insurance coverage for their independent contractors who have signed an agreement with the work made for hire clause. It's basically including these magic words in a contractor agreement is going to have, by operation of law, the effect of making those contractors statutory employees for these important insurance coverage provisions under both the Labor Code and Unemployment Insurance Code. So as with other misclassification claims that I'm sure lots on this call are already aware of, whether the agreement refers to the worker as a contractor or an employee doesn't matter in this context. The status can still be legally challenged under these workers' compensation and unemployment insurance provisions. A question that Rebecca and I worry about sometimes in our practice is whether this conversion to statutory employee triggers rights to any other employee benefits, overtime, meal and rest breaks, compliant wage statements, the whole litany of employment protections that are provided under other provisions of the Labor Code. And surprisingly, we found that although law journal articles have been pinpointing this as a potential issue for some time now, the case law is very sparse on this. There's nothing binding in this area. And it seems unlikely that the legislature would have intended that federal copyright principles like this would automatically transform workers into employees for all purposes. If it wanted to do that, it should have said that, right? But given the dearth of case law in this area, and of course in California, the increasing focus on the classification of contractors versus employees in the gig economy, plaintiffs and state agencies involved in administrating the enforcement of worker classification may spring into action on this. And that's especially true given the codification of the ABC test for contractor classification in California. So, what this means, and I think, Nate, if we go to the next slide, we have some thoughts here on ways to kind of minimize this risk. Again, we don't view the operation of the work made for hire provision as likely and legally to create all these extra employment protections, but we've thought of some ways to try to minimize the risk of that. And so one obvious option would be to just abstain completely from including work made for hire clauses in your contractor agreements, and instead requiring the contractor to assign ownership of all deliverables to the creator. As Nate pointed out, the risk of this strategy, of course, is that if the creator can terminate the agreement after 35 years, that can be an unattractive potentiality for employers, that their contractors may start basically pulling back the rights that they had assigned 35 years ago. Of course, on the other hand, this risk is less of an issue for works that are supposed to be used for a limited period. Of course, for technologies, the life of most technologies, especially in this day and age, don't usually last a whole 35 years. But of course, there's some context where employers might be concerned about that assignment right. And so we're working, the other consideration here is that work made for hire clauses and the statutes that I pointed out earlier, those refer to individual rights. So another way to minimize risk here is to basically have entities sign contractor agreements instead of individuals. And so by having investing rights in an entity as opposed to an individual, there too might be a way to avoid this work made for hire statutory employee concept. The other ideas that we have here is that you could include the work made for hire clause, but specify that the creator is a statutory employee only for workers' compensation, disability, and unemployment insurance purposes, and is not otherwise an employee. So that's just a contractual verbiage that you could add in there. Of course, that's not normally bulletproof. Other options to again just minimize risk here is to retain some limited rights, to have the contractor retain some limited rights in the IP, the copyright interest. That can be one way to avoid triggering the workers' compensation labor code section, as well as the unemployment insurance code section, both of which by their terms apply if the commissioning party obtains ownership of all rights. So by having the contractor retain some limited rights, again, you might just avoid application of the statute entirely. So, just to kind of wrap up on this topic, whether or not a company includes a work made for hire clause, of course, it should always ensure that other features of the agreement and their actual practice certainly are consistent with contractor agreement under the applicable contractor test. So for a lot of companies now, it's going to be the ABC test. And then for those that are exempted by AB5, the Borello test. And whichever approach companies take, they should do so after balancing the above factors in terms of the IP considerations, looking at this on a case-by-case basis, and finally, as we'll highlight a lot in this presentation, rather than using the same template across the board, we definitely recommend customizing it for each circumstance and for each contractor.
Perfect, thank you. So one last topic in copyright is something you may hear about from time to time, and that is open source software. We hear a lot about open source software, and it's generally understood that open source software can be used without paying a fee for that software. And it is commonly used in the creation of new software products. Software developers use all sorts of open source in creating any new product. There are a couple of things you need to keep in mind as the employer. First of all, it's not the same as public domain. These are not items that nobody owns and that everybody has a right to. Instead, these are open source works, are owned by their owners, and they're licensed under the open source license. There are a number of different open source licenses, and they have very different terms. And it's important to understand the terms of any given license for a work that is being incorporated into your company's piece of software. And so the key here is to understand the licenses and educate your employees. Your software engineers have to understand that not all open source is created equal. Not all open source is available for use in company products. Some licenses are great for the company and simply require something like attribution. So it may require that a copyright notice be included within the software that's created, within that code. That's no problem. Done all the time, very easy to do. Other licenses might not require anything, no notice, no nothing, and that's great as well. The ones to be concerned about are those that allow you to use this piece of software in your new piece of software, if and only if you release the new piece of software under the same terms as the licensed open source piece. So suddenly your piece of software that you expected to be company owned and a company asset has to be released under an open source license that allows others to use it. That, as you could imagine, would be a problem. So the key here is to educate your employees, to have a process by which if your employees use open source code, it has to be considered by some individual that has authority over these things and approved for use in the company work. Again, lots of licenses out there. It's important that somebody be aware of what's being added or used in connection with company software that's being created. Moving off of copyright, just a quick aside on the right of publicity. This is, again, the use of others' name and likenesses, and these are state-based rights. California does have a right of publicity provision, a right of publicity law. Some other big ones are New York, Tennessee, and you can see that a lot of the states that have them, although others do as well, but are where movies, entertainment, music, that kind of stuff emanates, because it largely grew out of the idea that celebrities should be able to control their name and likeness. It's expanded beyond that, though, and now all individuals in California, for example, have a right of publicity concerning their name and likeness. So you can imagine some situations where you would like to use your employees' names or likeness publicly. Example would be maybe on your social media page, maybe on your website. There are lots of places that your employees might show up. And so for that, you would need their permission. So how do you get their permission? There are a few ways. You could include it in their employment agreement, very straightforward. You could also include it in an inventions assignment that you undertake at the time of the beginning of their employment. What about, though, non-employees, contractors and the like, or others that you simply don't have agreements with? Well, a lot of times companies host events and they want to use images from those events, and those events include people who aren't part of the company, who haven't signed an agreement. So what about signage at an event? That largely would work. At the end of the day, what you're really looking for is to put people on notice, to have a chilling effect against them suddenly finding their image somewhere on the internet. And so the signage usually satisfies that purpose, because at the end of the day, if you use somebody's likeness without their permission, they could take action in court and seek an injunction. It would be so expensive to do so that it's simply unlikely that anybody would take that step if their likeness is not worth a lot of money, like a celebrity. So the signage usually does the trick. At the end of the day, additionally, if somebody complains about their image being online, usually pretty easy to take care of that and remove it. And finally, in independent contractor agreements, is it worth it to include something on this? Well, how likely is it that you're going to include that contractor's name or likeness? If they are kind of working as along with the company and there's a relationship there and they're more likely to show up, or you want to talk about them, then yeah, I would include it, but it's probably not going to matter for most independent contractors. So enough on right of publicity, let's move on to patent. So who owns a patent? Always the inventor. Only people can be inventors. Companies cannot be inventors. In fact, it was determined that a monkey was not permitted to be an inventor, even though the monkey actually did invent the item. So at the end of the day, the bottom line is the individual inventor at your company is the owner of the patent in that thing that they create. Employment alone does not transfer that to the employer. So unlike the work made for hire doctrine under copyright, employees creating things in connection with their job do not transfer title to the company simply because they are employees. Instead, a formal assignment is required. And that's why you see very often in employment agreements or agreements that accompany employment agreements, the invention assignment agreements, you have these in place from the get-go. And it's really key with your employees, with contractors, and with founders to make sure that the company owns the patent rights in anything that's created for the company.
So Nate, I think we had a quick question on signage. What is
Sure.
signage relating to likeness?
Oh, sorry about that. So sorry, I wasn't clear at all. So what I'm talking about there is if you have an event, often you'll go to an event, say a charitable fundraiser, and you'll see a sign at the entrance that basically says, there's a photographer here, we're taking pictures, any pictures of you, may be used in our social media pages, and you, by attending, you're giving us your permission to use those images and your name, something to that effect. So that's the signage that I'm talking about, actual physical signs at a given event. I hope that answers the question. Feel free to email me, of course, with any follow-up questions on that. And thanks for calling out that question. As you know, my screen doesn't show the chat. So any other questions, please do call them out to me. On the patent assignment agreements, again, you want to get those in early. You want to have them in place so there's no question down the road. You can broadly define inventions, but you can actually go broader than those those inventions directly developed pursuant to the person's job as described. You can basically say anything that they create that is related to the employer's business or the employer's interests is covered by the invention assignment. It's key to include a present assignment of inventions, just like with copyright. And it is worthwhile, and this is true with copyright as well, to include an agreement that they'll execute another agreement if you need it to file with the patent office or the copyright office in connection with copyrights. That's just so that you don't have to file this big document to show that something was assigned to the company. You can just have a short and sweet, small, quick document that can be recorded anywhere, and you're not worried about the disclosure of other things in the agreement. So what are some pitfalls around patent? Well, the obvious one is having no assignment agreement and no assignment agreement at all. That would definitely be a problem. Pre-assignment is an issue that could occur if the assignment agreement takes place before the employment status is reached. So you should avoid that and do it in connection with employment. And then Rebecca's going to talk about some California Labor Code issues.
Yeah, so thanks, Nate. You may all be familiar with this provision, but there is a labor code provision, section 2870, which is included in the materials for today. So you'll have a copy of it, which basically states that any invention assignment agreement does not apply to inventions that are developed on the employee's own time without the use of the employer's facilities or equipment or information, et cetera. There are a couple of carve-outs for that restriction. So if the employee's invention meets the criteria, where they did it on their own time using their own supplies and devices, but the invention is related to the employer's business, that can still be assigned to the employer. Or if it results from any research or development or the employee's work at the company, it can still be assigned to the employer. Keep in mind that that disclosure has to be made in the invention assignment agreement. So in other words, when you're having an employee sign an invention assignment agreement, you need to expressly inform them of their rights that, certain things are not going to be assigned to the employer if they develop the inventions on their own time using their own supplies and devices. You do want to make those disclosures because Labor Code 2871 says that if you have an agreement that does purport to assign inventions made on the employee's own time using their own supplies and devices to the employer, it is void. Normally, what we recommend in those agreements is to have a form where the employee has to disclose any such inventions to the employer that they believe will not be assigned to the employer, that they were developed on their own time using the employee's own materials and supplies. And the Labor Code actually expressly allows for that and says that you can require employees to tell you, okay, here are the things I'm claiming are not assigned to you that are owned by me. And the employer is allowed to do sort of an investigation or an inquiry to determine whether it agrees with that characterization. But you definitely want to make sure that all of that is covered in your invention assignment agreement, just to make sure that the agreement itself remains enforceable and is not subject to challenge. One last point on this is that this would only apply in the context of an employment agreement. So by its terms, it would not be required for an independent contractor. But as Chandra alluded earlier, it's becoming increasingly challenging to correctly classify people as independent contractors in California, given the evolution of the law and the ABC test. So there may be situations where you're concerned that a particular contractor classification might be risky or maybe kind of on the line. And so in case-by-case situations like that, it may be worth including those disclosures anyway, just to avoid that agreement someday being subject to challenge by the worker.
Perfect. Thank you, Rebecca. A couple other points before we move on. First of all, work for hire or work made for hire has no meaning or effect in the patent world. It is solely a copyright concept. And so including work made for hire language has no effect here. Now, could it have an effect that we talked about earlier? Even though it has no intellectual property effect, it certainly could. So it's something to be certainly avoided in the patent area. Secondly, shop rights. I get a lot of questions from employers that say, yeah, but we have shop rights, so I don't really care if the individual assigned this or not. And that's true, but you get licensed rights and not ownership of the invention. So if your employee creates something and you don't have an assignment in place, but they create it in connection with their job, you will have shop rights and the employer will be able to use that invention for the purposes intended. Now, first of all, it's not always clear what those intended purposes are, and ambiguity can be a problem there and lead to disputes down the road. But perhaps more importantly, that license is non-transferable. So if you want to sell the business, if you want to sell that item that was created, you won't have the right to do so merely relying on shop rights. So shop rights enables you to use the invention, but it's just a license and shouldn't be relied on. And then lastly, the hired to invent doctrine. I get people asking me about this. And the idea here is that if you hire somebody to invent something very specific, you may well get ownership in it. However, it's not applicable to employees in general. So if you have an engineer that you've hired for lots of tasks, and under one of their tasks, they invent something, you're not going to get ownership of that item. It's not going to fall under the hired to invent doctrine. And so again, this is not something to rely on. Instead, it's really key to have those invention assignment agreements in place early in the relationship.
We had a question from Grace. How and when do you object to a patent application once it's filed with the USPTO?
So we would have our patent litigators talk to you about that one. and happy to connect you with people, but there are bases to oppose a patent application. The question is, how would you know that application is on file? It would be difficult to become aware of it. But after the registration, or if the patent is issued and then there's an attempt to enforce it against you, there are remedies to take at that time. You can look to cancel that patent. Again,
Thanks.
if anybody wants to hear, yeah.
Yeah, just a couple more questions on the previous topics before we change to trade secrets. Back to the assignment rights. Can a contractor waive their rights to terminate the assignment? I don't think they can.
That's to terminate the under the copyright assignment and termination.
Right.
The answer is murky. It's been addressed a couple of times, but no is the answer to it. You can't waive it. It will always be there, and they will be able to enforce it even if there was waiver language in the original agreement.
Great. And then I think the last one from the prior topics was the rationale behind requiring a company to provide workers' comp insurance for the independent contractor. I think here the rationale is if you're essentially taking rights away from an independent contractor, I think the workers' comp statute is viewing that as operationally creating rights in the employer that are more typical of an employer-employee relationship. And so for that reason, the workers' comp statute at least is saying you need to provide workers' compensation coverage for that individual, particularly when in the course of their work, performing these rights that are going to be creating these rights that are then going to vest in the company, that is a reason to have to provide workers' compensation coverage for that individual. There's no sort of policy statement in the statute that we're aware of, but I can see that as being sort of the rationale there, as well as for the unemployment insurance. If you're sort of treating people like employees by taking rights away from them that they're creating, they should also be, covered within your policies that are applicable to your workforce.
All right.
Great. Back to trade secrets.
Great, thank you. So on to trade secrets. So what's a trade secret? It's confidential information that has demonstrable economic value. So it's your secret sauce. It has value because it is kept secret. The minute it's out there for everybody else, it suddenly has no economic value to you because everybody else can do the same thing. So what are some examples? Formulas are kind of classic. The formula for Coke is probably the most famous trade secret protected item. Customer lists, very commonly protected as trade secrets. And then processes and recipes, again, that secret sauce idea. So how do you protect trade secrets? Well, the key is in keeping them secret. And how do you keep them secret? You have appropriate security. And that's not only online security that tries to keep hackers out and the like, but also physical security. That is, not enabling the situation where somebody can walk into your offices and learn that material, can understand those trade secrets and take them with them. And you say, well, what about the people that we have to let in? We have to give this information to certain people. And that's absolutely true. The key is you want to enter agreements with those people to contractually protect the confidentiality of that information. So with employees, it's part of their employment agreement or their inventions assignment agreement. With independent contractors, you want to have confidentiality provisions in those contractor agreements or have NDAs with contractors as you would with other third parties to whom you might have to disclose some of this information, investors, visitors, others. But having one of those agreements, the confidentiality protections in place is really key. And moving on to non-disclosure agreements specifically, I'll turn it back over to Chandra.
Thanks. So we wanted to touch on non-disclosure agreements. Let's see, we have a poll here that we can let folks answer first. So we've got Large majority on false. For NDAs should always be as broad as possible to lock down any and every potential secret. So that is the correct answer there from the majority.
Well done.
Well done. And so to tackle that point, we often see employers having, again, these kind of template recycled agreements that particularly protect confidential information. And confidential information is oftentimes just defined extremely broadly. It's the kind of kitchen sink approach. Let's put every conceivable word in there that people often associate with confidential information. And similarly, everybody under the sun that could potentially be affiliated with a company generally is included in there, officers, directors, trustees, all of the like. And we find that that approach is actually can be counterproductive. Courts who look at confidentiality agreements and are actually charged with enforcing them, if somebody were to bring a challenge to a confidentiality agreement, we could see this, for example, in a former employee who leaves. They want to use or talk about certain information from their prior job in the course of their new employment or just in the public generally, and they find themselves bound by this extremely broad confidentiality agreement. And so they might take that to the court and say, I need a declaratory relief that this confidentiality agreement is overly broad and in fact impinges on my rights to compete, right? As we all know, in California, there's prohibitions against non-compete agreements. And so by having an extremely broad confidentiality provision, and it actually gets looked at by a court, there's a chance that the overbreadth can itself be a reason to invalidate the confidentiality provision. Based on this non-compete concern. There's a case that we've seen called Brown versus TGS Management Company. That's 57 Cal. 5th 303, which held along these lines that an overbroad confidentiality provision can constitute an unlawful non-competition covenant in violation of section 16600 of the Business and Professions Code. So a heads up on that. Other areas where we can see pitfalls with overbroad confidentiality provisions is with contractors. Again, as Rebecca and I keep pointing out, with contractors, the ABC test really hones in on this concept of control. Is the employee or the contractor under the control of the employer? And that test will be the first factor for determining if somebody can properly be classified as a contractor. And so if you have an extremely overbroad confidentiality provision, that can be one factor a court would look at in saying that somebody was being controlled so much that they should in fact have been classified as an employee. And then with the NLRA, just to touch on that very briefly, Section 7 of the NLRA has protections for employees to be able to engage in concerted activities for their mutual aid and protection, which includes talking about the terms and conditions of their employment. And so an overly broad NDA, an overly broad social media policy, has been interpreted by the NLRB General Counsel as unenforceable under the National Labor Relations Act as impeding those rights. So, in terms of best practices here, that the key is to really customize the definition of confidential information. You really want to focus in on what you care about, right? So if your company develops software, then certainly software code, those types of things should certainly be in your confidentiality agreement. If you're a restaurant, probably not, right? So you want to just be very clear on what types of information matter to your business and have those be the ones that you highlight in the confidentiality agreement definition. So that's the thing for new employees to certainly highlight in terms of NDAs, and then also for departing employees. Very common for employers to have people leaving the company enter into severance agreements and or settlement agreements if they've brought legal claims. And there's been a couple of laws coming out of the 2018 Me Too movement that have limited the type of and the scope of NDAs that you can impose on folks who are entering settlement or severance agreements. And then just this month, Governor Newsom signed Senate Bill 331, which further limits the use of NDAs in this area. And so just to sort of highlight what SB 331 did, it built on SB 820, which came out in 2018, to basically expand the types of information that employers are not able to prohibit employees out the door from talking about. And that's, it's no longer just sexual harassment, sexual discrimination, sex-based wrongful misconduct, it now expands to any type of harassment, discrimination, retaliation that you can't bar folks from talking about. And then just to hit on a couple of other features of SB 331, it also requires that NDAs entered as a condition of employment, as well as severance and settlement agreements, cannot have non-disparagement agreements that prohibit talking about unlawful acts in the workplace unless there's very clear language and a carve out providing employees with just notification of their rights in that area. So a lot going on with SB 331. I won't dwell on it anymore, but something to be aware of. It takes effect in 2022.
Yeah, so for arbitration agreements, and we've often seen these thrown into invention assignment agreements, confidentiality agreements, employment agreements. Typically employers will just try to find a place to squeeze in an arbitration agreement for an employee or a contractor. The law in this area is really in flux right now because Assembly Bill 51 was passed effective January 1, 2020. And it banned mandatory arbitration as a condition of employment. It was pretty quickly challenged in the courts as being preempted by federal law. There's the Federal Arbitration Act, which has stated a broad policy of favoring arbitration agreements. There was a federal judge that pretty quickly enjoined the bill from taking effect and found that it likely was preempted by federal law. So AB 51 was basically stayed for a while throughout most of last year and this year. And then just last month, that case got to the Ninth Circuit, and the Ninth Circuit largely reversed the district court and found that there was no issue with the majority of AB 51, only certain portions of it that provided for like criminal penalties for employers that required mandatory arbitration. That was thrown out. But the policy generally was allowed to stand by the Ninth Circuit, and they basically found that it does not conflict with the Federal Arbitration Act because it just ensures that arbitration agreements are entered into voluntarily and not mandatory for employees. So the current state of that is that the Ninth Circuit ruling was issued last month. We expect there to be additional appeals, potentially an en banc Ninth Circuit hearing, probably going to the U.S. Supreme Court. There have been a lot of arbitration decisions going to the U.S. Supreme Court. So still not entirely clear where this is all going to pan out. But in the meantime, a couple of options for employers. Some employers are just continuing to require mandatory arbitration. Some employers just really feel strongly that this law is never actually going to take effect, that the Supreme Court will strike it down at some point in the future, and no issue with their arbitration agreements. Some employers have decided to make their arbitration agreements now voluntary or optional by adding language that says that employees are not required to sign this. It's a voluntary decision to enter into the arbitration agreement. Of course, that risks employees deciding that they don't want to sign the arbitration agreement. And then you could have something where, part of your workforce has agreed to arbitration, part of the workforce has not. Gets pretty complicated for employers to manage that. And then some employers have just decided to stop requiring arbitration. So these decisions are pretty much made on a case-by-case basis, depending on the employer, the nature of the workforce, the nature of the industry, all sorts of things, risk tolerance. So yeah, if you're not sure what to do about arbitration, definitely time to consult with counsel about what to do while this law is continuing to go back and forth through the courts.
Choice of law provisions. This is a key area in California since the passage of California Labor Code Section 925, which provides that an employer can't require employees who primarily reside and work in California to agree to a provision that requires adjudicating outside of California any claims arising in the state or deprive the employee of the substantive protection of California law and imposing those on employees as a condition of their employment. Any provision that violates the above is going to be voidable by the employee. So they can simply say, I don't need to abide by the choice of law that you've put in the agreement, and I also don't need to abide by the choice of forum that you've put in the agreement. I can enforce my rights in California under California law. There is an exception for where the employee is in fact individually represented by legal counsel in negotiating the terms of that agreement. And so that usually applies to more senior level, executive level employees who have the benefit of counsel in negotiating their employment agreement. Otherwise, most commonly, these types of choice of law and venue provisions are not going to be proper. And one thing we often see is where employers have a variety of different agreements for employees coming in, and their workforce is nationwide. Oftentimes, employers will have their employment agreement for people, and then separately the NDA, separately an IP agreement. And we've seen conflicting choice of law and choice of and forum provisions in those agreements. And so just another thing to look out for is making sure there's consistency for your California employees in terms of the choice of law, choice of forum.
Just a couple of quick reminders on provisions that we commonly see in confidentiality and IP agreements. As we've mentioned earlier in the presentation, non-compete agreements are generally unenforceable in California. There are a few exceptions for like owners of the business, partners in the business, people who've sold a portion of the business, but for the vast majority of employees, there should not be a non-compete agreement in their confidentiality agreements, employment agreement, anywhere. Non-solicitation agreements are sort of the new hot topic right now because there's a lot of uncertainty about whether non-solicitation agreements are going to be enforceable going forward. As the law currently stands, there's not an outright ban on non-solicitation agreements, but there have been cases deciding that overbroad non-solicitation agreements in certain industries can actually be very similar to non-competition agreements and therefore unenforceable. So there was a Court of Appeal decision a couple of years ago involving travel nurses staffing companies where recruiters had left one company and gone to another, but were prohibited from soliciting employees from the other company to come over to the new company. And given that the nature of their work was to actually solicit employees and recruit employees, the court found that that non-solicitation agreement was essentially a non-competition agreement and therefore unenforceable. So just keep in mind, non-solicitation agreements, I think at some point in the future probably will be deemed unenforceable in California, but right now it's a bit of a gray area.
And Rebecca, we had a question from Judith. What about non-competition agreements for independent contractors?
I believe, normally we don't recommend non-competition agreements in the state of California because it's actually under the Business and Professions Code that says non-competition agreements are unenforceable. So I would probably not recommend it, but it's something to consider maybe on a case-by-case basis, depending on what they're doing and the kind of work that they're doing, but probably not going to be enforceable under the Business and Professions Code. One helpful case that we just wanted to briefly cover, I know we have a couple of minutes left. This case came out last year, and it's actually pretty helpful for employers and deals with employer liability when employees take IP from a prior company to the new company. So what happened in this case, which is also in your materials, is Hooked Media Company. It was an app that would recommend other apps to mobile users. Apple and Hooked had met on a couple of occasions about Apple possibly acquiring the company, but those discussions sort of fizzled out. They also talked about potentially recruiting a couple of workers to come over to Apple. Those discussions also didn't really pan out, but eventually Apple did hire a couple of employees directly to the company. Hooked sent a letter to Apple basically saying that these employees have signed confidentiality agreements, IP agreements, and that they wanted to make sure that Apple was not going to infringe on Hooked's IP rights. Apple responded and said they had no intention of stealing any of Hooked's IP, that they would facilitate the return of anything that the employees had taken. Next slide. Hooked actually eventually sued the employees and Apple, claiming that the employees had stolen IP from their prior employment, came over to Apple, used it there. They filed a bunch of claims for trade secret misappropriation, unfair competition, a whole litany of things. And this is actually pretty common. Normally the new employer will be named as a defendant when employees take things over, even if there's no evidence that the new employer was involved or, wanted to do that. The court actually granted summary judgment for Apple, although there was some circumstantial evidence that the employees had taken IP and trade secrets from Hooked. The court found that there was no evidence that Apple actually was involved in that or, approved of it or encouraged it. And even though there were definitely similarities between the work that the employees had done at Hooked and the work that they did at Apple, the court found that that was actually insufficient to establish liability, and imposing liability on Apple for the employee's misconduct would actually be sort of like a de facto non-competition agreement that would prohibit Apple from, having employees come over and compete with other companies. So I think the big takeaways from this case are that, if you have sufficient processes and policies in place to prevent new employees from bringing over trade secrets and IP from a prior company, you can actually insulate your company from liability, even if the employees are later found to be liable for stealing things and taking things that they shouldn't have taken. So we'll just close out quickly. I'll turn it back over to Chandra for some takeaways and big picture topics here.
Great. So just to wrap up in terms of new employees and contractors, make sure you have appropriate agreements in place prior to at the start of employment. Discuss ownership issues and duties, and then document those conversations as well so everybody's clear on the IP rights and which direction they flow. That goes also to the importance of training, especially for non-technical employees who don't particularly understand IP issues, who are non-lawyers. Really good idea to provide training to people and answer questions they might have about the IP rights that they're signing away or agreeing to. And then employees outside California may be subject to just different rules and restrictive covenants, as we've touched on with the choice of law, Section 925, independent contractor rights, as well as the non-compete and non-solicit considerations Rebecca talked about. So having agreements that may work for your business to have different ones depending on the different states. And if you're going to have a single agreement that encompasses everybody, you normally need to follow the state that has the most restrictive and most employee-friendly protections. As far as departing employees and contractors, definitely require a disclosure of all the projects, products, deliverables that they've worked on so that it's clear what the scope of the rights that they did create in connection with their employment and who owns those rights. Make sure to inspect and examine their devices using sometimes, if appropriate, a forensic company to do that, to make sure people are not taking trade secrets with them out the door. We definitely recommend too requiring a signed agreement confirming that all the IP has been returned to the company, and also, of course, collecting the physical devices that folks may have used. We suggest procuring an assignment agreement if there's not already one in place. That can be done at the end of the relationship if that hasn't been perfected at the beginning. And then, of course, disabling folks' system access that they had and preserving any documents or data that are important, and of course, those that might potentially inhere in a litigation risk. So as we are 3 minutes over, we'll wrap up there. And I don't think we have time for more questions, but please feel free to reach out to any of us here with our email addresses on the slide for other questions or things that may come up.